My name is Stephanie Nitsch. I am an assistant professor at the Department of European, International and Comparative Law at the University of Vienna. And I would like to talk about the potential of private law in context of environmental and climate emergencies. By the end of this video, you will understand what private law is and why it plays a vital role in coping with environmental and climate emergencies. At a supermarket, did you ever wonder which product is the most climate-friendly? Especially when nowadays almost all products are sold with a green label or a green claim. Is there a legal framework that enables sustainable consumption decisions? And thinking of defective products, such as defective mobile phones, do consumers have a right to repair instead of replacement? And have you ever considered if and under which circumstances industries should be held accountable for contributing to climate change or environmental pollution? Should European corporations be held accountable for the conduct of their subsidiaries or business partners across the globe? A lot of legal mechanisms dealing with these issues are of a private law nature, and that field of law is the focus of my video today. The aim of environmental protection spreads through the entire spectrum of legal disciplines. Increasingly, also private law is identified as a possible pathway towards environmental protection. First, very briefly, I would like to define the term private law. Private law deals with relations between individuals rather than relations between individuals and the state. Relations between individuals and the state are subject to public law, which can be divided into many fields of law, such as administrative law, constitutional law, criminal law, but also tax law. Also, private law covers a wide range of legal fields, including property law, commercial law, and labor law, as well as many others. Within private law, there are a lot of approaches aiming at environmental protection. I will now give you some examples, but I would like to mention that there are many, many more. The first example is consumer law. Within consumer law, unfair trading law and contract law are drivers of sustainable consumption. Unfair trading law protects competitors, but also consumers from misleading commercial practices such as greenwashing. The most prominent examples of legislation are the European Green Claims Directive and the amendment to the European Directive concerning unfair business-to-consumer commercial practices. These directives introduce marketing requirements that ensure that consumers can make sustainable consumption decisions based on reliable, comparable, and verifiable sustainability information. Furthermore, under the new rules of the so-called Right to Repair Directive, consumers are enabled to seek repair instead of replacement. Furthermore, repair services will become more accessible, transparent, and attractive. With regard to sustainable consumption, consumer law can be considered to be more effective than administrative environmental law because this field of law empowers a large number of individuals, that is consumers, who together can make a significant difference. Next, I would like to talk about strategic litigation in context of climate change or global environmental pollution. Increasingly, lawsuits challenge corporations. Plaintiffs, that is those who sue corporations, claim that the defendants should be held liable because of their contribution to climate change or global environmental pollution, such as plastics pollution. In cases of the so-called climate change litigation, plaintiffs claim that defendants have a legal obligation to reduce their CO2 emissions, pay for adaptation measures, and provide compensation for damages. The complexity of these lawsuits lies in the principle of tort law, such as establishing causation and unlawful conduct. Furthermore, especially in context of climate change litigation, there is an ongoing debate whether courts can decide on such a matter or whether this would exceed judicial competence. Nevertheless, these forms of litigation draw attention, and from a global perspective, these proceedings are gaining momentum. As another example of liability law, I would like to mention the Directive on Corporate Sustainability Due Diligence, the so-called CSDDD. The aim of the CSDDD is to foster sustainable and responsible corporate behavior across the global value chains. Companies that fall under the CSDDD have to identify and address adverse impacts of their actions on human rights and the environment inside, but also outside Europe. This means it addresses the company's own operations, but also the operations of their subsidiaries, and where related to their value chains, the operations of their business partners. Furthermore, the CSDDD introduces an obligation to adopt and put into effect a transition plan for climate change mitigation. The rules will be enforced through administrative supervision, but also liability of a private law nature. Member states shall ensure that a company can be held liable for damage caused to a natural or a legal person if the company intentionally or negligently failed to comply with its obligations. This liability is part of private law and makes supply chain liability more effective. As we could see, private law is a possible pathway towards environmental protection. It can enable sustainable consumption, and it can increase corporate responsibility.